right, this is Alex Mogensen.
The loss of Erin, my wife, my best friend, my partner, the love of my life, and the mother of my child has devastated me. Not only has this person taken Erin from me and our family and the community, he stole our unborn child and the future that we had planned, and we're honestly still planning for us and our new family. I understand that whatever decision is made today in court will not bring Erin or my child back. But maybe we can save the life of others that this person would also destroy carelessly. I ask the court to give the maximum of each charge served consecutively with no chance of parole or opportunity to serve at home. This person at every point of this has tried to avoid responsibility by either running or denying. In my opinion, if this person were ever to leave custody, he would run again, likely putting more people in danger. And that is all.
Thank you. Thank you, sir. Thanks for all the speakers. I'm very sorry for your losses. We're going to go back to Mr. Lonsky.
Those are the speakers. Judge, you heard the trial in the case. I'm just going to very briefly go over the evidence. It started with the squad camera on the body camera of the Wauwatosa police officer who sees the BMW SUV, sees that it has no plates, gets behind it to stop it, and lights it up, and it speeds up. Goes so fast that it gains several blocks distance on the squad, who wisely abandons the chase, given that no plates is not a serious enough infraction to endanger the community over. And the car continues speeding, runs a red light, and T-bones the victim. Immediately he gets out of the car, he runs through the gas station parking lot. There's a video of him doing that. He ends up getting caught at a 39th Street address. At that address, there is the key fob that works the car. There's some paperwork that's being burned in a grill in the backyard, along with what appears to be a hoodie. The neighbor who lives there happened that morning to take a photograph of the car before the accident, because it had parked so close to her car that it was obstructing her, or something like that. And also within that car there was a receipt. Within the crashed car there was the Walmart receipt that was traced back to the Walmart videos that showed a person who was obviously the defendant. There were tattoos on his hands. There was a hoodie consistent with, was that left in the car? Yeah. There was the hoodie. On one of his hands there was a blemish. It was just obviously him in the Walmart video. When he was arrested, he, I should note, the owner of the car that he was driving reported it stolen. And reported it about a week before, the day after, he said that it was stolen at night, and I think the owner came to the police in the morning to report it stolen. I'm not sure really if it was stolen or not. The defendant, when he was arrested, the defendant admitted getting the car from the owner, but he said it wasn't stolen, it was lent to him, and he had it stolen from him. Then he basically distanced himself from the car, saying, yeah, I had the car once, and then somebody else stole it from me, and that happened before Walmart. He denied that it was him on the Walmart video or driving it on the day of the crime. I didn't use that statement at trial. I kind of kept it in my back pocket if he would testify. The evidence that I did present was so strong I didn't think I needed it. But it was would have been pretty damaging if I put it in, because it was basically him sitting there denying that the Walmart person was him when it was so overwhelmingly obvious that it was him, given the tattoos and the blemishes and all the other things you could see on the video. So it would have made him look like a bald-faced liar. That was the evidence at trial that I used, and some of it that I chose not to. This is a very egregious and serious crime. Here we got 2 deaths involved. There have been plenty of, it's sad to say, but there have been plenty of fatal accidents in Milwaukee recently. And a lot of those have been charged as second-degree reckless homicide, because the one element that distinguishes first degree from second degree is utter disregard for human life. This one was charged as first degree, and the jury agreed with that assessment of the defendant having shown utter disregard for human life. He did that in a lot of ways, simply going 116 miles an hour at one point. The reason for doing it was to escape the police, whether he was afraid they were he was in trouble for the car that for some reason he had removed the plates from, or some other thing he had in the car that he didn't want the police to find out about. Who knows? But he whatever he wants to get away for, he goes 116 miles an hour up Capitol Drive. He slows down for a red light, but he's going so fast to begin with that the best he can do is get down into the 70s, which is devastating speed to T-bone somebody going 70 miles an hour. That was the best he could do by hitting the brakes, is get all the way, get it down to 70. Then how does he react? He reacts by running from the scene, leaving the devastation behind, not seeing who he had hit, and whether he could help, whether he could save a life or more than one life. He didn't know how many people were in that car. And then he tries to destroy the evidence. And when police confront him about it, and question him about it, he lies. I was surprised to see in the pre-sentence that he does now say that he did this. He admits it, and he is being remorseful. It's always hard for me to judge sincerity. I'll leave that to the court. It could be very well that he is apologetic, or it could simply be that he's smart enough to know that he might come out with a better sentence if he presents himself as apologetic. So I'll leave it to the court, but I do note that he does admit what he did and acknowledges the wrongfulness of that. The community is fed up with this kind of crime. I mean, this case prompted people to get together and form this group that's been coming to various traffic cases in court. They're just fed up with it. And rightfully so. A lot of people live their lives to avoid the dramas that the court system sees every day. Most in these homicide courts, a lot of these homicides happen because the victims, for one reason or another, get involved in situations that are risky. Whether it's a fight in a tavern, whether it's a drug deal in an alley, whether it's they're trading guns, stolen guns, or whatever. The people are involved in these situations that put them at risk. But with these traffic things, it's just ordinary people who are avoiding the drama, avoiding crime. They have nothing to do with it. They're just innocent people going about their lives, And here we are, you know, people like you and me driving home from work tonight, just going about our lives, and we're at risk of getting killed. People are sick and tired of that, and it's become a big problem in Milwaukee. The defendants, I looked at his character, take it into account when making a recommendation, and there's good things about it. I mean, he finished high school. You don't see a lot of that in homicides court. Looks like he had better than average grades, we'll call it that. He had some behavioral trouble in high school, but he finished. I give him a lot of credit for that. His criminal history, it's chronic. It doesn't stop. Getting probation for it doesn't seem to stop it, but it's all retail theft. He basically presents as a thief, not as a violent criminal. So he doesn't come here with a clean record. He comes here with I'll call it a relatively lengthy record, but it's all the same type of crime, retail theft. So where does that leave me as far as recommendation? I understand exactly where the family is coming from, wanting this whole, all these charges to be maxed out consecutively. I looked at what the pre-sentence writer wrote, and this was an unusual situation for me, where when I read what the pre-sentence writer, the writer was pretty much in the same area as I added up. She's asking on each count for the writer is asking on each count for there to be a consecutive sentence. On counts 1 and 2, asking for the range of initial confinement of 16 to 20 years. On counts 3 and 4, asking for the initial confinement to be between 4 and 5 years. You add that up, and the writer is recommending between 40 and 50 years of initial confinement. And when I added up the consecutive extended supervision, that would be 20 to 28 years of that. I agree with the number 40 for the initial confinement. Whether the court, how the court gets there between all the counts is really an academic matter, almost in my view. I think there should be consecutive counts for the two lives that were taken, but I think 40 years is an appropriate amount of initial confinement. That's what I'm going to ask the court to impose.
Thank you. All right.